Good afternoon and welcome everyone. My name is Baljinder Gill. I'm the Community Training and Outreach Coordinator with Legal Aid BC. On behalf of Law Foundation and Legal Aid BC, I welcome you all. Before we start the session, I would like to begin by acknowledging the land on which we gather is the traditional unceded territory of the Coast Salish peoples, including the territories of the Musqueam, Squamish, Tsleil-Waututh First Nations. I'm thankful to Kayla and Anna both for providing such a strong help to make these sessions successful every day. Without them, we are not able to do them. And I'm ready to introduce our wonderful speakers for today. We have Thea McDonagh. Thea is Director of Advocacy with TAPS. We have Daniel Jackson. He's a staff lawyer with TAPS. Andrew Robb. He's the staff lawyer with Disability Law Clinic. And we have Alison Ward. I think everybody knows Alison. And she is the lawyer with Community Advocate Support Line with CLAS. It's my privilege to welcome you all and thank you for joining us in today's session.
Okay, welcome everybody to Welfare for Senior Advocates. That slide that we just started with just had my name on it, but of course I have three wonderful colleagues presenting here today. So I just want to talk a little bit about how the session's going to run, and then we're going to move right into substantive presentations. We have 2 hours for the session today, and we have 5 cases to present. So that's roughly 25 minutes per case. So we're going to try and move things through fairly quickly. We'd like to have an interactive session. So what we're thinking is that each person will do their presentation. We'll have questions at the end of each presentation. We have 5 different subject areas that we're presenting on. In terms of how questions can be asked, primarily, we're going to use the chat. Somebody's going to be monitoring the chat throughout. So if you have a question, put it in the chat. If you have a question that you feel is complicated and would take, it's too difficult to write it out in detail, say in the chat, it's like raising your hand, say, I'd like to ask a question verbally, and then time permitting, we will call on the person with the question and have you ask your question. So I'm just going to run through an outline of what we're going to be talking about today. So we're going to kick off with Andrew. So Andrew Robb is the lawyer at the Disability Law Clinic. He's going to be presenting a tribunal decision about monthly nutritional supplement. Then Thea has a case presentation about moving and storage supplement decision. And then Daniel is going to be reviewing a tribunal decision he worked on this year involving a crisis supplement for a new furnace. And then I'm presenting a case. It's not actually my case. It's a case that Paul Lagasse and Prince Rupert worked on, but he wasn't available today, so I'm presenting that for him. It's about a Section 10 information and verification sanction. And then we're moving back to Andrew, who's doing double duty today. He has a dental decision from the tribunal to talk about. So that's the outline for the session. And with that, I'm going to turn things over to Andrew for your monthly nutritional supplement.
Thank you, Alison. So as you heard, I'm Andrew Robb. My pronouns are he and him. I am the staff lawyer at the new Disability Law Clinic at Disability Alliance BC. Before I begin my discussion, I want to give a brief shout out to my colleague, Annette Murray. Annette is DABC's senior PWD advocate, who knows far more than I do about the ministry's rules and procedures. And she has helped me to learn a lot in the brief time that I have been at DABC. As Alison said, I will be discussing 2 cases today, and they are in fact actually both Annette's cases. In one of them, I represented the client because Annette was not available at the time of the hearing. But the other case, Annette took to the tribunal herself, and I'm only presenting it because, unfortunately, she could not be here today. I also wanted to mention this title slide we're looking at now shows the logo for the Disability Law Clinic, even though I am only one of the presenters that you'll see today, and the others are not from the Disability Law Clinic, but I could not figure out how to get rid of that logo without taking it off all my slides. So I apologize for any confusion. Can we go to the next slide, please? Right, thank you. So as Alison said, the first case I'll be discussing is related to the monthly nutritional supplement. And the website that I have listed under there is just the website for the Employment and Assistance Appeal Tribunal's page where you can find the decision in this case. The decision was also a copy of the decision has also been uploaded to the SCED website. So you can find it on there and you can find it online at this link right here if you are interested during or after my presentation in knowing a little more about what happened in this case. Next slide, please. Thank you. So the issue in this case was really how much detail is required from the practitioner who fills out the application for the monthly nutritional supplement form. In other words, the MNS form. And as you know, the practitioner can be a doctor or a nurse practitioner or a dietitian. I think those are the practitioners who can fill in the form. In my case, it was a doctor, so I'm going to switch back between saying doctor and practitioner. Whoever it is, the form asks that person to answer questions about the applicant's medical conditions and symptoms. And the form says you must provide this information in detail, but it gives the practitioner very limited space to do so. And so in my case, the doctor did provide a certain level of detail. Nevertheless, at reconsideration, the application for the MNS was denied, partly on the basis that the practitioner had not provided sufficient detail. So the facts in the case, and if you look at the decision, you'll find a lot more than just what I'm saying here, but I'm trying to summarize the most important ones. The applicant's diagnoses included, there was a very long list of diagnoses and disabilities, but the main ones that the doctor relied on in recommending the MNS were IBS, migraines, and disc problems, in other words, vertebrae problems causing severe chronic pain. The application form filled out by the doctor said that the applicant had symptoms including malnutrition, muscle mass loss, significant neurological degeneration related to the chronic migraines. And the form also said that she had lost 15 kilograms in the past 2 years. And this became important because it was interesting that where the doctor wrote that she had lost 15 kilograms in the past 2 years was not the part of the form where he should have written it. It was sort of just on the right side of the page instead of being in the box where the information should have gone. And as a result of that, it appeared that the ministry, when they made their decision, did not even notice that part of what the doctor had written. So I'll talk in a second, I'll talk more about how the tribunal dealt with that problem. In the form, I mean, the doctor wrote, as I said before, the doctor did provide a pretty good level of detail. In particular, the doctor wrote that in addition to regular dietary intake, the applicant requires daily intake of extra calories in the form of fresh produce, fish, poultry, and lean red meat. The doctor also wrote that the applicant's medical condition is at a stage where nutritional intervention is required to alleviate the wasting symptoms and reduce the rate of further deterioration and health risks. And my understanding is that in previous MNS cases involving other applicants, terminology very similar to this did result in the applicant being successful and receiving the MNS. So one of the challenges here, as I'll discuss more in a few minutes, one of the challenges here was that we were dealing with, it looked like very similar facts to cases we'd seen before where the MNS was granted. And so I know that we were a little perplexed why it wasn't granted in this case. And that's one of the reasons it seemed like a good case to take to the tribunal. At the reconsideration level, the ministry said, among other things, it said, based on the information provided, you have a severe medical condition. However, it is unclear that you are being treated for a chronic progressive deterioration of health. The ministry also wrote that evidence of wasting is not clearly indicated on the MNS application. And I took issue with both of these findings. I mean, I think they both were pretty clearly contradicted by what the doctor had said. the reconsideration decision also found there was no evidence of significant weight loss. And as I said before, it did not refer at all to the doctor's statement that the applicant had lost 15 kilograms in the past 2 years. And I can't remember, I mean, the form also listed the applicant's weight, and I can't remember exactly what it was, but it was not, I mean, 15 kilograms was a very significant part of that weight. I think it worked out to approximately 20% of the applicant's total body weight. So 15 kilograms was not an insignificant amount of weight for her to lose. So in the next couple of slides, I have just listed some of the things that the tribunal said in its decision rescinding the ministry decision. I want to mention that it was, and I'll talk more about this in a second, but it was an oral hearing. Now this was post-COVID, so it was an oral hearing by teleconference, of course, nobody was meeting in person. And I had also sent in written submissions ahead of time so that the panel and the ministry, the tribunal panel and the ministry knew more or less what I was going to be saying at the hearing. And the tribunal really picked up on a lot of my written submissions. And so most of what I'm going to show you that the tribunal said in its decision, much of that was really picking up on what I had written to them ahead of time. So one of the things the tribunal said was, given the physician's evidence in the MNS form, where he responds in the positive in numerous places on the form to the question, is the applicant being treated for a chronic progressive deterioration of health? The panel finds it was not reasonable for the ministry to determine that in the opinion of this physician, there was not enough evidence of chronic progressive deterioration of health. And I had pointed out that what the form says, it does not say, are they being treated for a chronic progressive deterioration of health, yes or no? It says, are they being treated for that? And if so, please provide detail. And the doctor had provided detail. The doctor had not said specifically, yes, they are being treated for a chronic progressive deterioration of health, but in response to that question, they provided detail about exactly what was about approximately what was happening to the person's health. And so I argued that just by answering the question, just by providing detail in response to that question, the doctor was implicitly answering yes, the applicant is being treated for a chronic progressive deterioration of health. The MNS form, the tribunal also said, the MNS form states that the physician should describe how the appellant meets the symptoms, quote, in detail, but only 3/4 of a line is given for the physician to provide comments. And in this case, the doctor had filled out most of the space available, right? I mean, if there was 3/4 of a line available to them, they took up most of that space in their comments, and yet the tribunal found that there still wasn't enough detail. And I think the message they were trying to send to the ministry was, if you want detail, you better leave the doctor, the practitioner, whoever it is, enough space to give that level of detail. But if you're only giving them 3/4 of a line, you can't possibly expect them to go into a very specific level of detail about the condition that they're describing. I'm just including this to burn the ministry, really. There's more quotes from the tribunal's decision. It said, the ministry makes no notation of the 15 kilogram weight loss in their decision. When asked about this at the hearing, the ministry representative explained that weight loss and muscle mass loss were not the same thing. The ministry representative was not able to point to any medical evidence that supported this statement. And the tribunal also said on sort of the same point, with respect to significant deterioration of a vital organ, which is one of the criteria for receiving the MNS, the ministry wrote that the stomach was not a vital organ and that there were only 5 vital organs. There was no medical evidence supporting the ministry's determination that the stomach is not considered a vital organ. And I think the argument at the tribunal was, the 5 vital organs are the heart, the brain, the lungs, the kidney, and the liver. I think that's what they said. But that is not what the regulation says. That's not what the rules says. The rules say there must be deterioration of a vital organ. And if the legislation had wanted that to mean specific organs, it would have said so rather than saying just a vital organ. And so my argument was, well, look, I need my stomach. I think it's pretty vital. And the ministry said, well, the ministry didn't exactly say it's not vital, but they said it's not one of the most important ones. And the tribunal sort of slapped them down for that, in the sense that without medical evidence, it is not for the ministry to say one organ is vital and another one is not. Similarly, the tribunal found the ministry relies on the fact that the appellant is overweight according to a body mass index calculation. The source of how this calculation was conducted was not provided as evidence in the hearing. And what had happened was that the doctor had provided the individual's weight and their height, and the ministry just said, well, looking at the weight and the height, it appears that this individual is obese and therefore does not need extra calories. And I, in my submission, said that is a very troubling position for the ministry to take, because they were sort of saying, well, we can see her weight, and based on that, we think we know something about her health that the doctor isn't saying here. And I think the point that I tried to make was a person's weight is obviously an important part of their health, but you can't read, just because you know their weight, you can't read into that the person is overweight or doesn't need any new calories. And again, the tribunal really picked up on that and criticized the ministry for drawing these conclusions that were really medical conclusions without any medical expertise, without any medical evidence to support it. So what was challenging about this case, and as I said before, is partly that the same terminology used by the doctor in this case had previously been effective in securing the MNS for applicants in other cases. And so I think when Annette and I were working on this case, it was really surprising that that we needed to go to the tribunal at all. Like, I think it was really expected that, given the language that the doctor used in the form, surely the ministry was going to grant this application just like it had in similar applications in the past. And so it was surprising to us that we had to go to the tribunal to deal with this after that. I've written the reconsideration was, the decision was unambiguous in rejecting the request. It said the applicant did not meet any of the requirements for the MNS. And I realized after I wrote this slide, that's not correct, that they did acknowledge that the applicant met one or two of the criteria for the MNS, but not the others. Nevertheless, it was really surprising how the strong language in which the reconsideration decision found that the applicant was not entitled to the MNS. But it appeared that that was based partly on the fact that the ministry had completely overlooked important evidence. In other words, that part where the doctor wrote that she lost 15 kilograms in the past 2 years. And I think that was, partly the doctor's fault, in the sense that the doctor didn't put that information in the right place on the form, but it was there. And it seemed like whoever reviewed the decision at the ministry just took a very quick glance at the form rather than reviewing it in detail and making sure that they had seen all of the important evidence. And I think that's part of the reason why we ended up having to go to the tribunal in this case. So two main lessons learned for me here. One is a substantive point of law, and one is sort of a procedural strategy issue. The substantive point of law is, and I think this is true in many areas of administrative law, not just in cases with respect to the Ministry of Social Development and Poverty Reduction, when a decision maker does not even refer to important evidence, it is probably an unreasonable decision. That is to say, there is a rule in administrative law that the decision maker is not required to refer to every single piece of evidence when they give their reasons. However, if there is an important piece of evidence that contradicts the conclusion reached by the decision maker has an obligation to refer to that at least and explain why that evidence, that they reached an opposite conclusion, in other words. So again, the ministry the decision maker doesn't always have to refer to every piece of evidence, but if there is important evidence that they didn't refer to at all, and then they came to a conclusion not consistent with that evidence, that is a good marker that the decision is unreasonable, and you should consider an appeal to the tribunal in a case like this. My point on strategy is, and this is my experience in many different areas of law and many different types of tribunals, an oral hearing with written submissions is the most effective way to make your point, because it gives you the most opportunities to do that. My written submissions in this case were pretty aggressive. I was calling the decision inexplicable, incomprehensible, overlooked, completely ignored important evidence. And the first thing that the minister's representative said when they came into the hearing was, I didn't write this, just so you know, like they were basically apologizing for it throughout the decision. And the panel was really asking the minister's representative aggressive questions. Like it was pretty clear that they were hearing what I was saying. An oral hearing also really gives you the opportunity to go through the evidence in painstaking detail. What I have always found is that even though you put evidence before a tribunal, unfortunately, you can't always count on them looking closely at every part of that evidence. And so it is usually important to go through it in detail, even if they gave us an hour for this hearing, and I think we took an hour and a half. They gave me some pushback on that, but I said, I want to make sure that you see every single piece of evidence here. And I went through the doctor's form in great detail. And I think it is important to have an opportunity to do that, because otherwise there's just no way to know for sure if the tribunal heard what you were saying, if they saw the evidence that you were trying to point at. So I think that is the end of my presentation on this case. I don't know if we have time for some questions right now or if we're going to do that later, but I'm certainly happy to take any questions, whether it's now or later. Thank you.
I actually have a question for Andrew. It's Thea. I just thought I really liked your point about going over. Oh, can you hear me?
I can hear you, Thea.
Okay,
I can't see you, but I can hear you.
Okay, I can start my video. Sorry. Here I am. I liked your point about going over the evidence, your oral submissions in detail, and noted that you got a little bit of pushback from panel members on that. And I have felt that before at tribunal as well, where they kind of want you to say, we've got your written submissions, just save us all some time here. Let's not go over it word by word. I'm just curious if you could speak more to how you handled that in the hearing.
I guess it wasn't quite that. I mean, they weren't maybe that aggressive with me. They didn't say, we've read that, we want you to move on. They did note that we were coming up on the hour and they had another hearing scheduled. And I said, well, I'm mindful of the time. However, I do need the opportunity to make my submissions here. And I think that would generally be my response to that. Anytime that a tribunal is not allowing a person to make the submissions they want to make, there's going to be some possible basis for a review because of that. I mean, it is very important that a person, I think it is a rule in administrative law that a person is entitled to make submissions. Now, I hear what you're saying. If they said, we already got those submissions in writing, there's no need to repeat them again here. I think that's when I would at that point shift to the evidence and I'd start saying, I appreciate that. I might point out, just as I said on page 3 of my submissions or whatever, it is important to look at the exact evidence that came up in this case. But I understand what you're saying, and I don't know if I have a really good answer for that. I mean, sometimes you do have to go along with what the tribunal is saying. However, you do, I mean, I would suggest being very emphatic and aggressive in making sure that you have the opportunity to say your point. And if that means you need to say to the tribunal, with all due respect, I need time to make my submissions, I think the tribunal does have an obligation to respect that. They might not, but I think their obligation is to do it.
No, I think that's really good advice. People shouldn't feel rushed.
They'll try to rush you. I mean, that's part of their job. And I think part of what you can say is, well, I got a job here to do too, and it's to make sure that you understand what I'm saying.
Mm-hmm.
I might not be able to answer that question in a satisfactory way because I wasn't the one who prepared those submissions in the first place, or the initial application. And my understanding that the same terminology had worked in previous cases is based on something I'd heard from my colleagues rather than any of my own personal experience. So perhaps others can comment on that. But I know what you mean is that the ministry doesn't like the idea that there are advocates out there telling doctors what they need to say if they want their patients to get a supplement or to get qualified for some particular type of benefit. I think the answer to that has got to be, if it's true, it's true, right? I mean, even if the doctor is writing the same thing over and over again, or if different doctors are saying the same thing because you've told them what they need to say to make the application successful, I think responsibility is really on the doctor there. I mean, if the doctor's a professional, if they don't think it's true, they're not going to write it. So I'm not surprised that you get criticized sometimes for these cookie cutter submissions, but I think the criticism is, I mean, it's got to go to the person who signs the form. And if it's criticism, the answer to it is, you know, maybe it's been said before, but it's true in this case. But I certainly welcome anyone else's thoughts on that, because I know that's an issue I've heard about other people having to deal with as well.
Thank you.
I also think, just briefly, that you can, I mean, the ministry has an obligation to administer their services consistently. And so if something is accepted on one hand and not accepted on the other in a similar circumstance, I think that you can point that out to them without, I mean, I don't see why you would be reprimanded for saying this is that you're being inconsistent. And that's a fairness issue.
I agree. I mean, I think the law as we know it now says that administrative decision makers don't have to be consistent, but there better be a good explanation for it if they're not, right? I mean, if they see the same language in application forms and keep coming to different results, they better be pointing to something else in the evidence that explains that different conclusion.
So, and I think, there we go. Someone's going to do my PowerPoint for me. Thank you, Kayla. So this case was a moving supplement reconsideration. It was successful at reconsideration, so it didn't go to appeal. I think maybe one of the reasons we're including it is that it's there was changes to the legislation last year in July, and this case highlights a number of those changes. So if we could go to the next slide. Ooh, I forgot I have that fancy rollout of the fade in. So the legal issue in this case was the client was denied additional funds to cover the costs of storing her belongings during a move. And the ministry in their denial decision cited the two reasons. One, that she had already received funding from the ministry for moving and storage costs and therefore had resources. And two, that she did not obtain prior approval from the ministry before incurring the costs. So just as, sorry, you're going to hear the little ding on my computer there. Just as a quick reminder, the changes from last July there were a number of changes, but the ones that apply here were that was to include evictions for any reason. So people could access a moving supplement if they were evicted or compelled to vacate their premises for any reason, including evictions that were not legal under the RTA. To include storage costs if they were needed to preserve the person's belongings during the course of the move, as well as to provide discretion to the minister to provide the supplement even if the person did not receive prior approval before incurring the costs, if the minister is satisfied that exceptional circumstances existed. So if we go to the next slide, I'll give you a brief overview of the facts of the case. So this client had left an abusive relationship the prior year in May 2019. In March 2020, she received a letter from the owners of the house she was living in that named her ex-spouse as the rightful tenant of that home and asking her to vacate immediately, which she did. She vacated that same day, contacting the ministry the next day to request a moving supplement. And she requested funds for moving and storing her belongings because she had nowhere to move her stuff to because it was so unexpected. And she was told at that point that the ministry would provide her with funds to move her belongings and 2 months of storage. Following this, there was a number of circumstances outside of her control, and she had to request additional costs twice. And the third time she was denied. So some of the circumstances, just to give you a little bit of a sense of what happened, she was initially provided with approximately $800. This money was stolen, and so she had to request additional funds. You'll see, on the SCED, I gave you the denial decision as well as my submission. It's all been redacted, but it's up there if you would like to refer to it now or later. So she requested more funds, which she received. Then when she went to collect her belongings with a rental truck, the owner of the property came to the property and told her she had to leave by a certain time. And so she was unable to get all of her belongings on that day when she had the truck. And so she had to request more funds to rent the truck for a second day, which she got. And at that point, when she got the funds for the truck for a second day, she was told by the ministry, that's it, this is your full and final payment. You're not going to get any more money for this move. She then went to unload her belongings into a storage facility, and this was on March 19th, so right in the height of the pandemic escalation. And she's unloading her belongings, and the staff of the facility comes up and says, we've just received direction that we have to shut down. Everybody has to leave. We're closing the facility because of the public health orders. So the client contacts the ministry right away, says, I'm not going to be able to unload everything today. I need another day with the truck. The ministry was able to contact the storage facility and convince them to stay open longer so the client could continue to unload her belongings, which she did. It's now about 5 o'clock in the afternoon, and the client realizes that she's not going to be able to get all of her belongings into one storage locker, and she needs another storage locker to fit everything. The facility happens to have one other one that they can rent to her, but the ministry's now closed and she can't phone for prior approval. So she's in this position where she either has to keep the truck and ask for more funds for the truck and another locker, or go ahead, rent the second locker, and hope the ministry will cover the cost. So can we go to the next slide? So I want to say it was pretty straightforward. It wasn't straightforward because it was in the middle of the pandemic and it was quite difficult to work on this file, but as far as the legal steps taken, it was fairly straightforward. I just had to work with the client to establish the background facts and timeline in order to determine the merit of her reconsideration, which she was denied. The client had been through a lot and did not have a very strong memory, so it was really difficult to get her version of events to line up both with the ministry's version of events. So it was difficult to get those facts and the timeline sorted out. It took quite a lot of work. But even though I wasn't 100% confident in the timeline, we determined that there was still merit to pursue the reconsideration because at the end of the day, the client was asking for money related to her move. There were certainly exceptional circumstances which could offset the fact that she didn't get prior approval. and that given her circumstances plus the pandemic, those were the exceptional circumstances. Anyway, so the other thing that had to happen in the middle of it was that because of the timeline that it took to submit the reconsideration, she incurred like her second bill, her second month came up on the storage. So that was a bit tricky because we had to submit a service request for the ministry to pay the second month on one locker that they had approved, the first locker, but but also noting that the second locker was under reconsideration. So we were able to do that and get the funding for the second month. And then at that point, we would just had to submit, gather up some evidence. Again, that was tricky with COVID. She had to get a letter from her psychiatrist as well as invoices from the storage facility. Yeah. So the reason that we went with the psychiatrist, evidence from the psychiatrist, was part of our argument was that the belongings had to be in storage because the client was living in a motel and didn't have room from them. Her psychiatrist had given her really specific medical advice to not to move again, to just stay put. Her mental health was such that she needed some stability for a while, as well as there was a pandemic happening. So we got a letter from the psychiatrist that outlined that. If we could go to the next slide. Okay, so I already spoke a bit about it was challenging. It was complicated by different versions of events between the ministry and the client. One of the things I did was contact the ministry and try and get them to just walk me through all the case notes on the client's file because the client's memory was so poor. And that was challenging. The worker that I spoke with said, that the notes on the client's file were very confusing, and it took quite a bit of time to just wade through everything and try and piece together what had happened. And also just try to piece apart the fact that there was 2 storage lockers, one that had been approved and one that was under reconsideration. And then, so that was quite a bit of back and forth communication. COVID made everything more challenging. Getting consent to connect with her psychiatrist as well as the storage company was tricky. And I think if we go to lessons learned, I think, go to the next slide. Couple of things. One, prior approval is no longer required if extraordinary circumstances exist. So this is a good example of how that helped this client. I would just want to pick up on what Andrew was talking about in the ministry's decision. So if you have a chance to look at the ministry's denial decision, you'll see that it also was unambiguous. So for example, at one point they say that she was advised at this point that there would be no more money available to her for this move. That decision wasn't really based on anything in law. They were just saying, we've given you enough money right now and we don't want to give you any more. This is it. And so to just be aware of how the decisions are written, as well as sometimes maybe the tone of the decision. There was, they talked about how much money they had already given her, the fact that she had already got her maximum crisis supplement as well, which didn't apply to her moving supplement request at all. As well as that there's potential for errors in the ministry decision. So in this case, I really feel like both sides of it, the client's version of events and the ministry's version of events, had errors. And it was sort of a balancing act of trying to figure out what actually transpired somewhere in between both those events or both those versions. And really reading the ministry's denial decision from a perspective of that not necessarily gospel. And then also there currently is no limit on how long storage can be covered for, nor how much can be provided. So in this case, they had, as I said, they said that no more is available to you, but there is no limit defined. The only limitation is that it can be provided during the course of a move. And so there could later be more definition of that. That could be further defined, but at this point, that's all it says. And it's still fairly new enough that we haven't seen any decisions yet that say how long a course of a move can be. I don't know if anyone else in the province has, but we haven't. So that opens up the potential for, continuing to request storage fees if there's reasonable assumption that the move is still ongoing. And I think that is it as far as this case goes. I don't know if anyone has any questions. I think one other thing I'll just say briefly is I think this was a better example of how a lack of prior approval can work, necessarily more so than no other resources. So the ministry had cited both those reasons as denying her. I think now, if we had had the same case, the ministry would be much more likely to push back on the resources. At this time, during the pandemic, I think the ministry was being quite liberal with issuing funds. So when it got to Recon, I don't think they pushed back too hard on the resources. I also think at the time, they had yet to get the $300 COVID supplement when she was moving. So now I know that the ministry is sort of asking for more explanation of why the $300 is not enough resources for people.
Looks like we have one question in the chat. Do you see that?
Yeah, and I agree. Yeah, that's where I would have gone, where I would go with that. The question is there an argument that the $300 COVID supplement is for COVID expenses and shouldn't be expected to be used for reasons unrelated to COVID? What I said was that we're hearing the ministry push back more on crisis supplements than moving supplements, but to say, like, we're already providing you this other $300. Why is that not sufficient to cover whatever circumstances? And I think, yes, there isn't. I don't think we have time necessarily today, but it would be interested to hear other people's experience with that.
Hi, everyone. So hopefully my PowerPoint is just about to appear on your screens. So my name is Daniel Jackson. I use he, his pronouns. I work like Thea at the Together Against Poverty Society in Victoria. I have also uploaded materials to the SCED. I may have uploaded 2 sets in an effort to condense things, but anything with crisis, EAT, or furnace in it is related to this matter, and I can put a link to the decision, which is also up on the EAT website. So The legal issues, I think, should be pretty familiar to most of you. Crisis supplement, there's three criteria: unexpected need, no other resources available, and that the failure to meet the need or obtain the item, whatever it is, will result in imminent danger to a person's physical health. So that's the legal basis. The facts are relatively straightforward. So this is an applicant who's received PWD assistance for many years. She lives, for those that are familiar with Vancouver Island, on the top of the Malahat. So at relatively high elevation for us on the island here. And all of this is occurring in sort of late November through early January of last year, which was quite a snowy and cold winter again for us on the island. So her furnace fails, and she asked the ministry for a crisis supplement, first to repair, and then as time goes on and she talks to more furnace technicians, eventually to replace, because it turns out her furnace company is out of business, to replace her furnace and some of the ducting that it uses to heat her home. She lives in a 2-bedroom, sort of a mobile home up on top of the Malahat there. So she gets some quotes. She provides those to the ministry. It's about $15,000 to do this work, including delivery and all this stuff to her location. And as will become important later, the other major fact is that the applicant has a small wood stove in one of the rooms of her house. That's where she's at. She goes through the first 2 steps of the process on her own. So she applies to the crisis supplement and she fills out the reconsideration paperwork herself. And I'll just walk you through what the ministry said at each of those stages. So the first denial at initial was, as you see here, that this upgrade or repair is not unexpected. This is normal maintenance of your furnace or of any piece of your house, and therefore you fail on the unexpected need criteria. The ministry said that she should have been budgeting for this for years. The furnace was quite old at the time that it failed, I think 20 years old. And so there's no way that that failure could be considered unexpected. And the client came back in her reconsideration request, and again, all these documents are on the SCED. You can see what she wrote and what she argued, and said, well, maybe repairing it would have been something I could predict, but replacing the whole thing, the company folding, that wasn't expected, and I shouldn't have to pay these costs. And the ministry agreed with that argument at reconsideration. So here's a couple paragraphs on your screen from their decision. But basically, they said, yeah, okay, you might want to replace a part of a furnace, you should see that coming, but to replace the whole thing, because the company no longer exists, that meets the criteria for unexpected need. But the reconsideration officer reviewed the client's file history and found some conversation or conversations in the past where she had said to a worker, possibly in the course of requesting funds for wood, that she used her wood stove for heat because it was cheaper than her oil furnace. And the ministry said in the reconsideration decision, well, you haven't said anything to us indicating that you can't use this wood stove to heat your whole house, so you fail on the imminent harm criteria. So even if you don't replace your furnace, it seems to us you have a stove and you should be fine using that stove to get you through the winter. So denied at reconsideration. And this is when the client came to TAPS for some assistance with appealing this to the tribunal. In fact, she filed that paperwork herself and had already received an adjournment when she came to us in late December of last year. And so I've got some paragraphs from the decision. I'll say a couple things about what went into prepping for the hearing. It was a very short notice because the client had already used up one adjournment. And as I said earlier, the weather was turning and it was quite cold. So this is a very urgent application from her perspective to try to get some heat in her home. She was quite literally running out of wood. So we didn't have a ton of time to prepare. I prepared basic submissions and a couple key pieces of evidence. One was a very brief note from her physician, just confirming that she had a couple of specific physical difficulties and that moving a bunch of wood around throughout the winter wasn't really realistic for her. And then also a bit of a floor plan, basically, of her house, illustrating, the size of the house, where the wood stove was relative to other rooms, to just make it apparent to the ministry what the setup was. And then we attended the hearing. The applicant actually was unable to attend because she was snowed in that day at her house, so she attended by phone. And a colleague and I attended the hearing in person and made those arguments. I'll talk again a bit about, similar to how Andrew phrased it, in terms of how we, I think, convinced the panel. And we also, like I said, did written submissions. So here's some highlights from that decision that I thought were important to point out. So the main one is that the panel was quite obviously displeased in the hearing and in the decision. They capture some of that with the fact that the ministry knew this person, like the reason she had PWD assistance was because she had some physical impairments. So the ministry, in its file record history rather, was well aware that the ministry, or that the applicant, had these difficulties, and yet went on to conclude that she could use a wood stove as her only source of heat through the winter without appearing to consider in any way how her disabilities might affect her ability to use that stove. And so they pressed the minister's representative in the hearing on this point. Did they consider this? If so, in what way? And the representative, again, similar to Andrew's case, basically put their hands up and said, I didn't write this. I don't know what steps were taken. I mean, of course, as a matter of policy, we do, but I can't point to anything in this decision that indicates the ministry turned their mind to that interaction between this person's disabilities and the sort of logical outcome that they came to. And on that basis alone, the decision was unreasonable. They also looked at the sort of realisticness of whether this one wood stove in a corner of one room was capable of heating the house, including living areas, kitchen, bedroom. The stove is in the living room, as is typical maybe, and found also on that basis that this wasn't realistic. And so if you read the full decision, you'll see that we made those substantive arguments, and we also made a procedural argument that this whole bit about the wood stove was only ever put to the applicant in the reconsideration denial. And she, I think, quite convincingly in her testimony in the hearing, made the point that, if any ministry worker had asked her, could she use the stove to heat her house, she could have made all these arguments that she ended up making to the tribunal about her own physical limitations, the difficulty of getting enough wood delivered to her location, and simply the insufficiency of this stove to heat her house. And so we also argued that it was unfair that she'd be denied on this basis when, in the initial decision, the ministry didn't seem concerned about this, and no one raised it until sort of the last minute. And the panel also seemed receptive to that idea. So there were several grounds in the decision that they overturned. On. Just looking for my slide here. And then the last point there, I think also worth noting that, again, the appellant testified very convincingly that she was alone incapable of maintaining the wood and cutting the wood and all this sort of taking the steps she needed to take to heat her home. And she'd been getting help with that, which explained, why she was still able to live in her house to this point without a furnace. And the panel found conclusively that you can't expect a person to rely on the goodwill or the assistance of other people, potentially as a result of their disabilities, in order to sort of complete the course of action that the ministry has deemed as reasonable. So the decision was overturned, sent back to the minister for a decision on the precise amount that they would grant, but it was in the neighborhood of the $15,000 for the full furnace replacement. And I have a few more thoughts beyond what's on this brief slide here. But the first is this whole idea of unexpected need. This, I think, is often the most challenging part of a crisis supplement. And I think this decision is helpful in that or at least encouraging in that, there's room within that rubric to say, okay, if the client is legitimately did not anticipate this need, maybe even if they should have, you can still make that argument. And the ministry was fairly receptive to that here. And then again, the big one, there's an obligation on the ministry in these sorts of cases where someone's receiving disability assistance to consider how that disability interacts with the rest of their life in considering things like moving supplements, crisis supplements. So even if the person doesn't explicitly raise that, there's an obligation there for the ministry to look at that and to think about that if they're going to attempt to deny someone a supplement like this. And I would argue that it's just as relevant for a moving supplement as it is for a crisis supplement like this. And I think you can leverage that positive obligation, even, I think, for example, if we hadn't gotten an updated letter from the doctor. I mean, the letter was very brief and didn't add anything to the record the ministry already had. I think we would have been successful in that argument, even without the letter. But obviously having a current letter is helpful. And then just to riff on a couple of points that Andrew made before we turn it over to questions. Again, his point about, the ministry needs to point to specific evidence. And if you have a compelling piece of evidence that you think makes the case a slam dunk and the ministry just seems to ignore it or not address it, they can't do that. They have an obligation not to necessarily address every single piece of evidence, but to address the critical pieces. And I think part of what this case says is that a person's capacity vis-a-vis their disabilities can be one of those critical pieces that they need to address in their reasons, even if it wasn't explicitly raised by the person. If it's raised by implication due to the nature of the thing that they're requesting, I think that positive obligation to examine and address in the reasons exists. And then a strategy point. Again, I had a very similar experience to Andrew where the ministry representative, I think this is typical, is not the person that wrote the decision. They can't speak to what actually went into creating that decision, to the logic that was followed. So if the logic isn't apparent from the decision itself, I think it's advantageous to push really hard on that and to force them into a position of trying to defend this decision and to explain to the panel how it was that the minister came to the conclusions that they did. Because unless it specifically says, it's likely that person won't be able to do that convincingly. That's been my experience in past hearings and this one as well, where the representative wasn't able to answer the panel's questions about, well, how did you think this could possibly be true? How did you think the wood stove could heat the whole house? How did you think a person with these conditions could chop wood and do all these things? And there's no convincing answer. I mean, there isn't a convincing answer to those questions, but it helps to have the representative fail to respond to those questions convincingly in the hearing. So that was how that case went. Very good result for the client, although not as timely as we would have hoped. But I'm happy now to take questions. I'll stop my screen share and take a glance at the chat.
Move on to the next segment. So I have a PowerPoint that I will just get going here. And hopefully you can see my screen. All right, so I'm doing a short presentation on the Section 10 issue, and I'm presenting it on behalf of Paul Lagasse, that I think many of you know. He wasn't able to make it to the session today, so we reviewed it together, and I'm going to present my understanding of the issue. It's a case that was resolved at the initial issue, at the initial level with PLMS, so no reconsideration decision, no tribunal decision, so it should be quite short. So the legal issue was simply that the client who had the PWD designation had been cut off assistance under Section 10 for non-compliance with requests from the ministry. He had received a number of ministry letters over time. And just to review for anyone not familiar, Section 10 of the both pieces of welfare legislation allows the ministry to request information and verification of basically anything that's relevant to eligibility for benefits or supplements. And if that information is not supplied, it can then sanction the person until the ministry is satisfied that the person has complied with the requests. just going to review their powers to sanction under Section 10, because as with Thea's case, there have been some recent changes to that section. So it was the case. So I'll say, first of all, this case that Paul was dealing with happened in 2017, 2018. It's a little dated now. So at the time that he was dealing with it, the only sanction that was available to the ministry was to cut a family unit off benefits if there was a Section 10 sanction imposed, and the Section 10 cutoff would apply until such time as the family unit was in compliance with the Section 10 requests. So obviously that's a very serious sort of backhand way of kind of a loophole way that many clients end up ineligible for benefits. And I think many of you have seen situations like that. So thankfully, we now have changes to the legislation as of January of this year. So now the ministry now has two choices. So if it decides to impose a sanction under Section 10, the ministry may either reduce a family unit's benefits by $25 a month, or it may declare them ineligible until they comply. So those two choices are always available to the ministry in any Section 10 case now. But if there is a further condition, there's a section of the regulation that actually says now that if the ministry is satisfied that somebody is homeless or at imminent risk of homelessness, then the option of cutting the person off does not exist under Section 10. So if there is someone that the ministry thinks is homeless or about to become homeless, the ministry, the only discretion they have is to reduce their benefits by $25 a month until the person is in compliance. So, but as I said, Paul's case happened before that change, and so you need to remember that as we're moving through the case. And one of the questions that I've asked myself as I was thinking about the case is, if that same client came into Paul's office now or your office now, how would it be dealt with differently under this change in the legislation? All right, so the situation involved a client that I've called David. He was cut off disability assistance in August 2017 because he hadn't responded to letters from PLMS. Right after he was cut off, he immediately became homeless. He was an Indigenous man, or he is an Indigenous man who has serious cognitive impairment. He had received, I think, 4 different letters from PLMS over a period of I think it was 8 or 10 months. And he did not understand the letters that he was receiving from PLMS, which unfortunately is a situation I think many of us have seen before. He went to see Paul for the first time in June 2018. So that was 10 months after he'd been cut off, which means that he was homeless throughout the winter in Prince Rupert, which is very cold and rainy, and had a very tough time during those 10 months. When he went in to see Paul, he did take a copy of the most recent letter that he'd received from PLMS with him. So I've turned it into a slide. I don't know if you were able to read it. The type is quite small, but it's a letter that many of you have probably seen. This particular letter is not the format of the letter that PLMS now uses, but it is, if you actually read it, it is quite wordy. It's very text heavy. It says things that don't really make sense. It says we wrote to him back in August, September, October, and now this letter is dated June 22nd. And it says you haven't supplied all the information that we need. And if you don't provide it by, it doesn't give a deadline. It just says by the earliest possible date, your current eligibility cannot be determined. Although the guy had been off benefits already for 8 months, there's no deadline given. So he was completely mystified by this letter. He didn't know what to do, but he knew that he did need help, and he did eventually get in to see Paul. The attachment to the letter was a review checklist, which you can take a look at again. I hope you can see the font okay. You'll see that it likewise is not very clear. It asks for if you're renting a residential tenancy agreement, a rental agreement, and a current rent receipt, which is 3 documents to prove the same thing, which seems like a bit of overkill. And it also is very not specific to the person's situation. So in this case, the client was homeless. He obviously doesn't have any rent agreement or rent receipts. There's requests in there for confirmation of all accounts, assets, or investments, including RRSPs, RDSPs, etc. So again, that very broad kind of boilerplate letter that is not specific to the situation of the person that's receiving this information from PLMS. So the client went to see Paul. What did he do? Well, first he interviewed the client and found out, first of all, the severity of the client's cognitive issues, which, I'm removed from this case. I've never met the person. Paul said, if they'd asked him for a T4, he wouldn't have known what a T4 was. So he had many barriers and did have the PWD designation based on cognitive issues. He did also tell Paul said, well, why do you think your file was reviewed? And he said to Paul that, I was in the ministry office last summer. This is Prince Rupert, so I guess there's one ministry office. And while he was there, he mentioned that he had some work lined up on a boat for the summer. And as it turned out, he didn't report any earnings that summer. So there was some suspicion that maybe his file got flagged for that reason. In actual fact, the client had done some work on crab traps, like getting ready for the fishing season that summer. But he was a person that it was fairly easy to take advantage of, and he was taken advantage of because he did that work and was not paid, and the work on the boat never materialized. So he had no income to report to the ministry, and that was why he didn't report any, and yet his file was reviewed. When Paul looked over the letters from, there's a typo there, PLMS, the client didn't have any of the documents that the letters were asking for. And again, the letters were wordy and unclear and not tailored to the issue in the client's specific case. So Paul followed up with PLMS, explained the client's cognitive barriers and basic situation, and tried to get them to narrow down their requests and find out what they were actually concerned about. And it turned out that PLMS was able to do that and narrowed the issue down to simply needing to know if there had been any employment or income, or specifically fishing income, in a specific period of time that I think was from, I think it was January to November of 2017. So the issue Paul had then was that the client didn't have any records to show any of those things. How do you prove a negative? He'd had no income, he'd had no job, so he has no record of employment, he had no wages. And so therefore, showing a bank account with no deposits doesn't really disprove any of those allegations. So what Paul did was simply do an affirmed statement in these 3 paragraphs to the ministry, which was sent to PLMS, simply the client affirming he hadn't had any income in that period or record of employment, hadn't received any records of employment, and that he did some work but didn't receive any money as a result of the work that he'd done. So that was the half-page document that it took to resolve this poor fellow having been cut off and homeless for 10 months. And while it did resolve the situation in that his PWD benefits were reinstated as a result of this, Paul was left with a very bad taste in his mouth. I think that the challenge that he faced in the situation was, what do I do about this? He's back on benefits. I can't change the past. And yet, the situation with PLMS and the rapidity with which checks are flagged, and the failure in this particular case of PLMS to provide a client with cognitive limitations with any accommodation, was very troubling. Again, hearkening back to what Daniel was saying, the file, the ministry would have had the client's PWD application on file, and so knew or ought to have known that he had cognitive limitations, and yet PLMS apparently didn't review that information to determine whether or not this might be a client who required some assistance before cutting them off under Section 10. And again, we have the larger problem that the letters from PLMS were wordy and unclear, without deadlines, and not tailored to the client's specific situation, right? They're asking for investment accounts and not saying, look, the real issue here is, did you work in this specific period? Please prove that you did or didn't. So the approach that Paul took was he saw it basically as a systemic issue, and decided to try and get involved in trying to change some of the policy and letters that PLMS uses. So there are many people in the workshop today I know that are part of the consultation process with the ministry. And so this was a case that spurred Paul to join the Moving Forward Steering Committee. And at the same time, he also joined the PLMS subcommittee that several people in this workshop are also part of, and as I'm a part of that subcommittee as well. And so over the course of about a year, I think from 2018 to mid-2019, that subcommittee did a lot of work. We reviewed all of the PLMS letters that are sent out when information is being requested of clients for information and verification purposes, and also worked with the ministry on reworking the policy and procedures in the ministry policy manual for PLMS staff. And changes to both were implemented in April 2019. I'm sure some of you have seen the newer letters that the ministry is using when there are requests going out under Section 10 requests. I think they're much clearer than they used to be, and much more plain language. I'm sure they're not perfect. And if you're seeing problems with the letters that your clients are receiving, they could be clearer, they're misleading, they're causing clients to panic. Definitely the PLMS subcommittee would like to hear about that. I know one advocate recently commented to me that a client had received one of the new Section 10 request letters asking for information. And I think it was worded as your disability file is being reviewed. Can't remember the specific wording, but the wording caused the person to think that their PWD designation was under review, not just an eligibility issue. And so that caused the person a lot of panic. So that is wording that could be improved. And in terms of the policy and procedure that now applies to PLMS, the policy manual has been updated with that information. So if you take a look at it's under the compliance review title of the policy manual. And if you take a look at it, you will see that there are now like specific deadlines that are stipulated in the policy manual. So for example, if a request letter is sent out to a person, they're to be given 16 business days to respond. So it's approximately 3 weeks, allowing time for mailing, I guess, before any further action is to be taken. If no reply is received, the only action the ministry is supposed to take is to call the person a couple of times to see if they can reach them by phone, and if not, send a second letter, again with a 16 business day time frame for a response. There's specific provision that if a person, they're not, say, on the My Self-Serve portal, and they're not having, they may be no fixed address, or for some reason they are not receiving ministry correspondence, they're not dealing with ministry by mail, but rather picking up checks in the office, then the 16 business day deadline doesn't start to run until the day they pick up the check. And the letter from PLMS is to be included with the check in the envelope. So various procedural safeguards that have been written into the policy now. The policy also includes a section on the duty to accommodate. So in this case, where the client had disabilities, I think that section of the policy, if it had been applied as it stands now, would have made quite a difference. So it's clearly stipulated that staff is to review each case to see if accommodation is required, how they would do that, whether they would look at the PWD application form. And in reality, it's very difficult to know, but again, it is required by the policy. So if you see a situation where it hasn't happened, there may be remedies you can pursue. And there's also stipulation in the policy that if PLMS staff see an accommodation need, and they learn of an accommodation need that hasn't yet been flagged on the client's file, they're to add an accommodation alert. So you may remember a couple of years ago, the ministry introduced somewhere in this database, in their database, this alert function that I think is important for ministry staff, because if I understand it correctly, it like jumps to the front of any screen for the person's file, no matter what part of the ministry is dealing with them, or no matter what stage they're being dealt at. It's the accommodation alert is there so that it doesn't get buried, 10 screens down. So hopefully those things will be helpful in time. Maybe they would have made some difference to this client if they had been in effect, if the simplified letters had been in effect at the time the client had this issue, and the administrative fairness deadlines had been complied with more carefully by the ministry. The last thing I wanted to talk about was just for people advocates that are newer. I have included a slide about the consultation process, because I think that those of us that are involved with it don't always do a great job about communicating out about it. So I just want to make sure you're aware of all the pieces of it. There are three main pieces in the consultation structure. So there's this moving forward steering committee that a number of us sit on. Tish, who is the advocate co-chair of the steering committee. I think she's in the workshop today. And then the second piece is that we have several issue-specific subcommittees that deal with really practice and policy with regard to specific issues at the ministry. So PLMS, as I've already talked about today, there's also a CPP disability working group that basically is concerned with situations where the ministry is requiring people to apply for CPP disability, sometimes in situations where it's clear the person will not be eligible, or maybe they would be eligible, but they're trying to go back about 10 years and requiring them to get medical evidence from so long ago that it may not be reasonably available anymore. I've listed the contact person for each subcommittee. People can get involved in a specific subcommittee without being part of the steering committee itself. So if you have an interest, or you see cases that you think would be important for a committee to know about, please contact the person in charge of each specific subcommittee. So Sonia Marino, who we all just saw on screen a few minutes ago, is now the contact for the PLMS Compliance Review Group. Paul is for the CPP Disability Working Group. We also have a Reconsideration Appeal Rights Group and Dental Issues Group that I co-chair. I should say the Dental Issues Group is not about what should the ministry cover for dental. It's more about procedural issues about, at this point, I've lumped it together with Reconsideration and Appeal Rights, because it's kind of about the fact that the ministry actually never themselves notifies a client if they have been refused coverage for a dental issue. That notification comes from a dentist's office. And I think there are administrative fairness issues with that. So, and then the final subcommittee is a new committee to do with health benefits, including Schedule C issues and medical services only. And Annette Murray at DABC is the advocate co-chair for that committee. And then I'm sure you're all aware of the final piece of the consultation process, which is these quarterly consultation calls. that advocates in each region have with their community relations and service quality manager. If there's anyone in the workshop that isn't part of those calls yet and you would like to be, please contact the CRSQ at the ministry for your region. And that's it for me. If there's any questions, please drop them in the chat.
Sure. Hello again. And so this is my next presentation, and it's about a case that I call the dentures case. I think while we wait for the slides to come up for that, the first slide is going to show once again the website where you can find, there it is. On that website there, you can find the second decision by the tribunal in this case. As I'm going to discuss, there was actually two decisions by the tribunal about the very same situation in this case. Can we go to the next slide, please? I'm going to run through this one fairly quickly in the interest of time. The legal issue, as Alison said, is, I think, pretty interesting here. The question is, what is the effect of a decision by the tribunal to rescind the ministry's decision denying a supplement? And as we'll discuss, it is similar to the effect of a decision by the tribunal to rescind the ministry's decision regarding a designation, for example, the PWD designation. In this case, the applicant's initial request for a supplement was denied at reconsideration. And on appeal, the tribunal rescinded the reconsideration decision based on what I would probably call a technicality, just because the reconsideration decision cited the wrong part of the regulation. But after the tribunal rescinded the reconsideration decision, the issue went back to the ministry for a new decision, and the ministry made the exact same decision a second time. They still found the appellant was not entitled to the supplement, so the appellant then had to return to the tribunal again. Next slide, please. What happened exactly, I mean, the facts here are actually fairly straightforward. It's the policy and the law side of things that get complicated. And I'm simplifying these facts a little bit, but basically it's just in 2017, the appellant received funding from the ministry for dentures. In 2018, he lost those dentures, and it was accepted that that was not his fault. So the ministry decided to fund another set. Now, the regulation only appears to allow replacement dentures every 5 years, but it turned out the ministry had sort of I would say a compassion policy, allowing a one-time exemption to the 5-year replacement rule. But the next year, in 2019, he lost his dentures again, and he requested funding for, this would be a third set. The ministry once again accepted that the loss was not his fault, but this time they said, well, they're not going to make an exemption. They just cited the rule. Section 4.2 of Schedule C of the regulation says that you only get dentures every 5 years. At reconsideration, the ministry denied the appellant's request, and as I said, they cited the regulation, and all they did was they cited Section 63 of the regulation, which says the ministry can provide health supplements set out in Schedule C, Section 4, and they cited Schedule C, Section 4, which says, as I mentioned, that dentures may be provided as a basic dental service, but only once every 5 years. The ministry also cited Schedule C, Section 1, the definition of basic dental services. And the definition of basic dental services has, I think, 3 parts, A, B, and C. And in this case, they cited subsection A, which refers to services provided by a dentist. They did not cite subsection B, which refers to services provided by a denturist. The reconsideration also did not refer to the appellant's request for consideration of Section 64, which refers to emergency dental and denture supplements. So they did refer to certain aspects of the regulation, and they failed to refer to other aspects of the regulation, which the appellant had asked them to look at. So at the tribunal rescinded the reconsideration decision because it cited the wrong provision of the regulation. As I said before, it cited the reconsideration decision cited subsection A of the definition of basic dental services, which refers to services provided by a dentist. But the tribunal found the ministry should have cited subsection B, which refers to services provided by a denturist. The tribunal also criticized the reconsideration decision because it did not consider Section 64 of the regulation, which, as I mentioned, refers to requests for emergency care. The next bullet point is a quote from the decision, and it says, "Whether anything turns on these flaws is not for the panel to determine, but unless the ministry fully considers the appellant's request in light of all the relevant legislation, its decision cannot be considered reasonable." And the last bullet point here, this is my own editorial comment. The tribunal said whether anything turns in these flaws is not for the panel to determine. Well, nothing did. Like, it was fairly clear to me that even if the tribunal had, even if the ministry had considered the right sections, unfortunately, in these circumstances, the regulation probably did not allow them to fund another set of dentures for the appellant. And so this is what I mean when I say they rescinded the decision based basically on a technicality. But that does end up, nevertheless, becoming important. Let me go to the next slide, please. So at the reconsideration, in other words, at the decision of the ministry after the first tribunal decision, the ministry made a new decision, but it wasn't really a new decision. It was exactly the same as the first decision. They said they had no discretion to fund new dentures in the appellant's circumstances. In particular, they said the tribunal did not disagree with the reconsideration decision, and they're referring here to that first tribunal hearing that I just mentioned. The tribunal did not disagree with the reconsideration decision, but rescinded the decision as they were not satisfied the ministry took all relevant legislation into consideration. The ministry then provided a new decision, taking all legislation into consideration, and still found the appellant ineligible for the reasons provided in that decision. So now we're back to the tribunal. As I said, this is the take two at the tribunal. The ministry's written submission to the tribunal referred to a new ministry policy. And the new ministry policy said that they would immediately provide a supplement. I shouldn't say immediately. It said that they would provide a supplement if the tribunal rescinded a decision to deny it. And that was based on section 23 sub 3.1 of the regulation, which says, if the tribunal rescinds a decision of the minister refusing a supplement, the family unit is eligible for the supplement on the earlier of the dates referred to in subsection 23.3.01. And those dates are just the date of the reconsideration decision or 10 business days after the request for reconsideration was received. And there is also, I should add, there is an analogous provision of the regulation that says if the tribunal rescinds a decision of the minister refusing a designation, for example, the designation of a person as a person with disability, the family unit is eligible for the designation on the earlier of certain dates that are defined in the regulation. So we're going to talk more about the effect of that provision in just a second. But in this case, what the ministry said was this was a new policy. And it did not help the appellant because it only recently came into effect after the appellant's situation arose. And so the ministry was not willing to apply this so-called new policy retroactively. So the ministry said, we're still in the same place. We have no discretion. He's not entitled. He doesn't get the dentures, or he doesn't get the dentures again. So continuing, so this is further what the, more about what happened at the tribunal. After the ministry provided their submission referring to the so-called new policy, the appellant provided reply submissions, arguing that the new policy that the ministry cited was actually no different from its old policy, and the appellant was entitled to the supplement under either policy. As was noted in the reply submissions, the law had not changed. There had been no new major court decisions that might have affected the law. There was no reason why the ministry should be applying section 23 sub 3.1 differently now than they were before the decision was made. Before the decision was made. I should know, I'm going to get back to the issue of reply submissions in a second. But for now, it's important to note that the tribunal rescinded the new reconsideration decision based solely on section 23 sub 3.1 of the regulation. And the tribunal considered, and this is a quote for them at the end here, the tribunal said that the plain language of section 23 sub 3.1 shows the ministry must provide a supplement when the tribunal rescinds a decision to deny the supplement, regardless of whether eligibility criteria have been met. And so what this means, I think, is that even though the first tribunal decision overturned the reconsideration decision on a technicality. The tribunal certainly did not find that the individual was eligible for the supplement. It just said that the decision denying eligibility was not adequate. And so it was sent back to the ministry. And what this rule says is that as soon as it's sent back to the ministry by the tribunal, the appellant wins. The appellant gets the supplement he was asking for. Okay, so what was challenging about this case, there was a number of things, and I'm going to come back to the lessons learned, which I think are important. But the main thing that's challenging, as you all know who have dealt with PWD at all, the regulation is just stupidly complex. I mean, it's referring you to multiple schedules. In some cases, it refers to fee schedules for denturists and dentists and other service providers that are not even included in the regulation. It is very difficult to understand how the regulations are supposed to be interpreted. It was also challenging that the ministry violated its own policy when it made that second decision to deny the supplement, despite the tribunal decision rescinding the first ministry decision. And that is the reason why the appellant had to go through reconsideration and the tribunal twice on the same issue. And the other thing that was challenging about this case, from my understanding, and as I said before, this was not my case, it was my colleague Annette's, and I know that she worked closely with Alison on it, and they had to work a lot on it. I think Annette had to deal with this side of things, though. The appellant was a cantankerous fellow. He had been through a lot. He was disagreeable by any measure. And the reason why that made this whole, well, I mean, as you can imagine, that just makes everything more challenging. But in particular in this case, and I'm going to tell this just short story by way of epilogue before I move on. Even after the ministry finally, or even after the tribunal told the ministry that they had to fund the dentures, the case was not over yet because we could not find a dentist in town who was willing to deal with this guy. And so a large part of the work that I think Annette did on this case was not just dealing with the law, the tribunal, and the reconsideration decision. It was dealing with the dentist and begging them, can you please help this guy? Because if you don't help him, we're going to have to start from scratch, and it's just going to be such a pain. And so my only involvement in this case basically was after all the real work had been done, I got involved in trying to pressure the dentist to actually do the work that they had been paid for. And I can report that it was just, in fact, 3 weeks ago that this person had the new dentures installed. And so it looks like everything worked out in the end. But I'm sure you will all identify with the cantankerous nature of the fellow involved, just causing perhaps additional problems. And I'm not trying to blame this person. As I said, I mean, he'd been through a lot. I'm confident that a lot of his personality was a response to traumatic events that he had gone through, but it just does add that extra dimension of difficulty to everything. But that is not the main point that we want to make in this case. Can you please go to the next slide? Okay, so one thing I want to mention in terms of lesson learned is the right to make reply submissions. And I know that this is something that Alison has worked with the tribunal on, but it is true in law that when a party brings up a new issue in a response that has not previously been brought up, the appellant has a right to reply to that. And at the time of this case, the tribunal did not clearly spell out your right of reply. I think there's been some improvement on that issue since then, but sometimes you have to fight just to get your right to make further submissions to the tribunal. And you can only really have the right necessarily if something new was brought up by the ministry in their submissions that hadn't previously, that hadn't been brought up in the reconsideration decision. I think the more important thing, I shouldn't say more important. The other important thing that we want you to get from this case is this pretty technical rule, but it could be a very useful tool. It appears that if the tribunal rescinds a decision denying a supplement, and as I said, it also applies if the tribunal rescinds a decision denying a designation, if they do that for any reason, then the ministry must provide the supplement or the designation, even if the appellant is not entitled to it. I will say right away, it is questionable whether this is the correct interpretation of the law. However, to the best of our understanding, and Alison might be able to comment further, to the best of our understanding, it is the interpretation that the ministry is currently relying on. So the practical upshot of this is, if the evidence in favor of funding a supplement is not strong, and I think this would apply equally if the evidence in favor of designating someone as a person with disability is not strong, but the reconsideration decision includes any little error raises any fairness issue, no matter how minor it is worth appealing to the tribunal. I'm not going to say for sure you're going to win, but there is a window that appears to be open there that I'm not sure should be open, but if the tribunal and the ministry are opening it for us, that is a crack that we can try to get through. So it's worth appealing to the tribunal, even if you don't think you're going to win, if you can identify any little flaw in the reasoning or the procedure that they followed to get the reconsideration decision, because there is a chance that you might win, like I said before, on a technicality. Alison, do you think have I described that more or less correctly?
Yeah, I can try and jump in here. I can't get my video to go, I don't think. So
I can see you, Alison.
Oh, you can see me? Oh, I can't see myself. Okay. It is something that I did not see coming. As Andrew said, I work quite closely with Annette on this, both on the submission to the second EAT hearing and on the reply submission. So the second EAT hearing, so basically the substantive issue we thought was that this fellow is an older man, 77 years old on MSO. He had been homeless. He lost his dentures while he was homeless. He had a form of cancer and needed cancer treatment, got housed during treatment and was pursuing dentures. They were replacement dentures. The ministry had refused the application because the policy manual provides that the ministry can so the general rule is you can have replacement dentures once every 5 years. The policy manual says, oh, there's one exception. You can have a one-time exception to that one 5-year replacement rule if you lost them for reasons beyond your control and failing to have dentures will compromise your health. In this case, he'd already had one replacement within 5 years. This was the second replacement. So our submission to the EAT was all about, well, that policy exists and it's an application, it's an example illustrating that the ministry has discretion here. The ministry can't fetter its discretion by blindly following policy. The ministry at least needs to actively turn its mind to coverage here and so on and so forth. It was very much focused on dentures and why they should be covered. So when the ministry's submission to the tribunal was all about this thing saying, oh, we've received legal advice about how section 23 3.1, I think it is, should be interpreted. That really took us by surprise. And of course, we wanted to make reply submissions. I will say that once we brought the issue of reply submissions up with the tribunal, Emily Drown was very open to that. And I think that she's recognized that there needs to be provisions in the rules specifying that right of reply does exist and arise in certain circumstances. But what really I find interesting about this case is the way that the reconsideration or the direction that the reconsideration branch, I think, has received about how to treat situations where the tribunal rescinds a decision for any reason. And so I've asked for confirmation in writing from Reconsideration Branch for this information. They cannot provide it until after the election, but hopefully there will be some confirmation. But I can tell you what my understanding is. So as Andrew's reviewed, certainly it is that 23.3.1 of the disability regulation regarding supplements in this particular case. We saw that that is to be interpreted that if there is a rescind by the tribunal, the person is to receive the supplement, even if they don't meet we'll call it substantive, they haven't shown that they meet the substantive eligibility requirements for it. And there's also language in the regulations about the word rescind is also used in for EAPD. It's 23.3.2, which talks about tribunal rescinding a decision about the PPMB or PWD designation. So similarly, the language is if the tribunal rescinds a decision for any reason, the person is subsequently eligible for that designation. The part that I am very happily surprised by is that this is my understanding. So if we look at the section about supplements that Andrew referred to in his case presentation, 23.3.1 for the disability regulation and 26.3.1 of the employment and assistance regulation, it talks about rescinding decisions about supplements. So often we understand supplements to include, anything in Schedule C, crisis supplements, moving supplements. I think we use that language to refer to supplements, but my understanding here is that the ministry is actually interpreting supplement in this specific situation to also include income assistance and disability assistance and hardship assistance. Referring back to the definition of supplement in, I think it's Section 1 of both the Employment and Assistance Act and the Disability Act. Supplement is defined in those sections, and they're reading it, I think, possibly differently than I might read it, but my understanding is that the effect of the way they're reading it is that if the tribunal rescinds a decision about someone's eligibility, so let's say at reconsideration, they're found ineligible for income assistance because they have assets in excess or income in excess or some eligibility related reason, and the person appeals that decision to the tribunal and the tribunal rescinds the decision, the person wins. Let's say there's a procedural flaw at reconsideration. We have an issue like, say, Daniel's case, where reconsideration raises a whole new issue for refusing the issue. In the case of the crisis supplement, they said, oh, yes, your need is unexpected and you meet all the criteria, but Recon says you have a wood stove. This wasn't mentioned to you before. And so suddenly you're having to answer at the second level to a new issue, essentially. I think there could be an argument that that was procedurally unfair and that you could appeal that issue to the tribunal on the procedural issue alone, or maybe you want to make two arguments. A, you might want to argue A, she meets the substantive criteria, and B, even if she doesn't, you should rescind this decision because it's procedurally unfair or administratively unfair. And so if the tribunal were to rescind a decision about income assistance eligibility, say on a procedural fairness basis, this interpretation by the reconsideration branch would mean that the person would then, because the tribunal decision was rescinded, the person would then be eligible for income assistance if it was rescinded even on a procedural unfairness basis because of the way Section 23 is being interpreted. So I don't think I fully thought about all the ways that might be relevant, but I think it's quite interesting.
What I would say is if someone is considering making an argument like this, I would urge, this is a little tricky, and I think we're all saying we're not sure that the interpretation the ministry is giving us is correct here. I would urge anyone who is making an argument like this, talk to Alison or one of us. I think this is something that needs to be approached carefully, but potentially it could have a pretty dramatic impact in a good way. I think we just don't know for sure what's happening here. Yeah,
I think what it does do, I don't know what you think, Andrew, but I think what it does do, so we have this change this year, and we also have the rules about the much more liberal, relaxed rules about admission of new evidence at the tribunal. So I know you're new to BC, so I'll fill you in on the background. So the rate of success at the tribunal has been very low for the last, 8-10 years, if it's not a long time. We've seen clients succeeding in maybe 6-7% of cases. So advocates have really focused on pursuing issues very thoroughly at the reconsideration stage. And if somebody loses at reconsideration on certain issues, rather than appealing to the tribunal, it may be preferable, has been preferable in the past, to reapply for the benefit, say a PWD designation or something that you're able to reapply for. So I think this is really interesting because, with the broader rules of evidence at the tribunal, let's say you have a reconsideration decision on PWD, it should be possible to introduce pretty much any new evidence, like evidence that you might have gathered in the past for a reapplication. You should be able to have that admitted now at the tribunal. And also, if in addition the reconsideration decision raises some, if there's some reason to say that it was procedurally unfair, then you could be proceeding to tribunal on the two bases. A, they meet the substantive criteria for PWD designation in light of all this new evidence that you're now able to have admitted. And B, in the alternative, even if you haven't shown that they do, it was procedurally unfair and you should rescind on that basis alone. So I think it's tricky. I think this will obviously require more discussion and reflection than we have time for in a short presentation today. It would certainly help to have some confirmation in writing from the ministry. I did look at the policy and procedure manual has a section, I think the heading is tribunal, and there's a subsection about the effective date of tribunal decisions. It has not been updated since I think 2013. So this new information or this new, it's not a new policy, it's legal advice, I guess, that Reconsideration Branch received. It's not incorporated there yet. So yeah, I will be really interested to see how this develops and also to hear other people's thoughts about it. Just taking a quick look at the chat. Oh, Tish has a question. Or I don't know, Daniel, if you want to weigh in, or Thea.
So Tish's question is about the part of the tribunal decision forms where an issue can be referred back to the ministry as to amount. Mm-hmm. I suspect, and I mean, I think this is something we're still all figuring out, I suspect that if they refer it back as to amount, that will not have the same effect that we're talking about here. I think in order for the person to be automatically entitled to a supplement or a designation, the ministry has to rescind the decision and send it back to the ministry sort of in its entirety. I don't want to say I know that for sure, but that would be my impression.
Yeah, I think that's a section, I think it might be 24. It's a section about the tribunal's powers, which says basically the tribunal can confirm a decision or rescind a decision. Those are the only choices the tribunal has. And if the ministry rescinds a decision, but it needs further decision as to amount, then it goes back to the ministry for the amount decision. So say, for example, Daniel's furnace case, like we don't really know to the penny what a furnace costs. So they could have said, yes, your crisis supplement for a new furnace is granted in principle. We're referring it back to the ministry to make a decision about like the specific amount of the furnace, something like that. So I don't know. I think Tish will have to wait and see. I mean, I think those cases where they send it back for a decision about amount or as to an amount are pretty rare. So I haven't seen many of them.
So I think we are at the end of our session. Thank you, everyone. Thank you, Thea, Daniel, Andrew, and Alison. It was a wonderful wealth of information you shared with all the participants. Thank you so much. Thank you, Kayla. Thank you, Anna.